appeal that heard in the matter of SPM and certificate of stakeholder development.
Yes. Mr. Rowe.
Thank you.
Could you just give me one moment to sort out my...
Yes, of course.
Yes.
My Lord, I'll start, if I may, by emphasising 2 points, and then I'll come on to explain the structure of the submissions that I would propose to make. I hope relatively briefly, my own friend has done much of the hard work in taking the court through the material.
Yep.
I don't propose to take you through all the same stuff again, making points about it, not least for reasons of time. But the 2 points I want to emphasise at the outset are, first, that the claim is now purely a historical one. As recently as the replacement skeleton argument on the 31st of March of this year, the appellant was still asserting, in the present tense, that, with a handful of exceptions, women at Derwent's side never met their lawyers in person. In fact, we know now that from July last year onwards, the vast majority of them do meet their lawyers in person. And my learned friend confirmed in the course of his submissions yesterday that the target of the claim now is the historical position as it relates to the individual who is now his client. As your Lordship will recall, at first instance, this was a claim brought by SPM and by Women for Women Refugees, the organisation.
Yes. It is now solely SPM's claim.
Now it's solely SPM's claim. Yeah.
Also
it's SPM's appeal.
Appeal and claim.
Yeah, and claim. Yeah. Now, I mentioned that not to suggest that that fact by itself means that SPM's claim is automatically invalid. Plainly, she is entitled to be heard in this court on the circumstances that prevailed during her detention, and I suppose, subject to it being slightly unusual that she's bringing a claim in a sort of representative capacity without any formal orders to that effect, I suppose she's entitled to say, as my learned friend does, well, I'm focusing on the position up until the 1st of July, or thereabouts. That was when the new contract came into force and arrangements changed.
Just, are you going to at some point deal with that specific point you just made? Do you accept that SPM is entitled to seek the broader declaratory relief relating to the legality of the detention of other women at Derwent's side during the relevant period in circumstances where, as I understand it, she actually had face-to-face access to a lawyer, admittedly through a pro bono group, rather than through what might be called, rather than through the legal aid framework. So it's a point I personally would like to hear your views on, or what the Secretary of State's position is on whether it is appropriate for SPM to seek wider declaratory relief when her own position has been different.
Yes, all right. I will seek to revert on that. I mean, we've approached I approached the submissions obviously principally on the basis, as you'd expect, that we say in any event the claim doesn't succeed. I suppose the relevance of the question would arise.
Where speaking again for myself only, I don't want to be in a position of having two people putting polarised views and no sensible debate in the middle in case I wasn't with either of the polarised views.
Yes,
which I'm afraid is regrettably often the case.
Well, obviously, we hope that you'll be on one of the polarised views, preferably ours. But I'll come to that if I may.
Yeah.
Subsequently, I might on that specific question, just to be completely clear that I'm getting it right on instruction. Need to take instructions about that, because I have to say it's not a point that I've perhaps I should have done, but it's not a point that I've specifically come equipped on my feet to address, but I can deal with that, and I will do so.
Well, it sort of came out of my exchange with Mr. Goodman really right at the very end of yesterday, and did float in and out of the argument from time to time.
Yeah.
But when looking at the very specific relief, the 4 grounds that Mr. Goodman is pursuing are, if I remember correctly, I haven't got them in front of me, A and B are generic, class-wide, if I can put it that way, and I can't remember the letters, but it was maybe an E and F, E and
Yes.
J. Or
I think it's. I don't know whether you've got it yet, but
no, I
my
haven't.
learned friend was Butler handed over a tidied up version that puts it all into the present, into the past tense and
Yes, okay.
summarises it.
I have it. Okay, in which case,
D&E.
Appellant, is that appellant's note of relief sought? I think that's what you must be looking at.
yes, it's A and B are the generics, and C and D are specific to the appellant,
Yes.
I think.
Yeah.
Although slightly differently worded, but yeah, okay.
But my lord, I was just, as I say, making 2 initial points. I'd more or less completed the first one, emphasising the historical nature of the claim. But I do that not merely to point out that the claimant has abandoned part of her claim, but more importantly, as regards how the rest of the claim that remains should be disposed of, to point out that it does, in my submission, that the fact that the claim for the latter period has been abandoned does rather destroy, at least when one takes into account why it's been abandoned in reality, the rather colourful suggestion that the Secretary of State chose to ship people off into the desert, at least as regards availability of legal aid. Because, of course, we know that the statistics now show that from the 1st of July onwards last year, in fact, the vast majority of the appointments that were taking place at Derwent's were in-person appointments under the new contract.
Wait, sorry, I don't want to be occupying the airwaves, but you're missing the timing point there, aren't you? I mean, the suggestion is, or the way the case is put, is that the Secretary of State should not have detained people from the I can't remember the date in December 2021 to July 2022, because at that stage it was a desert. The water didn't arrive until July 2022, from which point it is no longer a desert. I mean that.
My lord, of course, I agree, and I'll have to deal with all of that. I don't mean this first point to go further than emphasising that there was nothing, as it were, inherent about the location that was objectionable. What is said to have been objectionable, and I'll come on to deal with this, was the state of affairs prevailing at the relevant time in relation to the availability of legal advice on a face-to-face basis. But I don't put it any higher than that. My lord, the second point is this, which is in a sense rather connected to the debate that we've just had, that the target of this claim is, and was in the court below, when, as I've said, it was also a claim being brought by Women for Women refugees, the Secretary of State's power to detain women at Derwent's. The Secretary of State is said, and we see this from the note of the relief that's sought, is said to have acted ultra vires in detaining the appellant and everybody else, as your lordship points out, at Derwent's from the date it opened in late December 2021 until the 1st of July 2022. Now, my lord, I mention that because one might think, bearing in mind that the complaint stems really from the quality or the nature of the advice that was provided to women detained at Derwent's, the manner in which it was provided, in other words, not face-to-face, but by telephone or over video conferencing. One might have thought, in the light of that the claimants might have directed their fire at the person responsible for the delivery of that advice, namely, as it is in practice, the Lord Chancellor through the legal aid system. But in fact, of course, as we've seen, they didn't make any such complaint. And in fact, they've not only not made such complaint, but they've expressly accepted that there was no breach of duty by the Lord Chancellor. I don't think that's controversial, but the court can see that at page 149 in the core bundle, where it's expressly made clear in the written submissions that took place after we ran out of time at the oral hearing, that the claimants do not argue that there is any breach of duty by the Lord Chancellor. I mention that because our submission, my Lord, is that this whole claim is really an attempt to squeeze what in substance is a complaint about the means by which legal advice was delivered, i.e. it should have been delivered face-to-face, says the claimant, into a framework that it doesn't really fit into, namely the framework we see in those cases upon which my learned friend relied. Anderson about the simultaneous ventilation rule in prisons, Unison about the employment tribunal fees, FB about the removal process that in practice could get people out of the jurisdiction before they could get access to a lawyer. And that's the fundamental difficulty in my submission with this claim. But because the claimants, plural below, and now the appellant in this court, have set their sights upon showing the detention itself to be unlawful rather than focusing on seeking to address the specific problem that arose in the course of the detention on their case, they have to try to get it within this framework of the principle of legality and the power to detain being limited such that it didn't arise in the particular circumstances of the appellant's case, or indeed, as the appellant contends, the case of anybody else who was detained at the centre until the 1st of July. And that's in my submission something which explains to some extent the difficulties with the claim. So in summary, my Lord, what we respectfully say about this appeal is this. First, we submit that the legal basis for the claim wasn't established and hasn't been established. Secondly, the factual basis for the claim wasn't and hasn't been established. And thirdly, that in any event, the assessment of the facts was, of course, a matter for the judge, with which this court cannot and will not interfere, unless persuaded, and this is obviously very familiar territory, unless persuaded either that the judge went wrong in principle in some way, or that she reached a conclusion which was rationally insupportable, and neither of which we submit is the case here. So,
Mr. Rowe, can I, just before you move on,
yeah.
This may not be the time to answer it, so if you want to just put a flag in and come back to it, that's fine. But on your second overarching point, do you say, which is that the focus of the attack, by attacking the detention, they've made a strategic error, or they've attacked the wrong decision. Do you say that their case logically must involve an attack on the decision to put in place temporary, I've forgotten the acronym for it now, but the 30 minutes DAS.
The DDAS.
DDAS.
Yeah.
Remote temporary DDAS, that they have to attack that as being a flawed, unlawful decision if they even want to begin to say that the detention itself was unlawful. I mean, there may be some connectors in between there that you want to attack as well, but that the logically prior attack must be to the DDAS and the adequacy of it, which I think you've said is that's not what they've attacked, and nor could they have attacked that properly. Is that where we're headed on this one?
Broadly speaking, Melody, yes. I mean, whether they could have attacked it, and if so, on what grounds, hasn't really been explored, and that would have been a quite different case if that had been done.
I just want to pick that up, because that would have been a case that said that remote DDAS is inadequate, it's ineffective because it breaches the unison principle. That would be the case they'd have to take.
I suppose, my lady, that's right. I mean, one doesn't want to elaborate a case on behalf of the claimant or anybody else who wants to run it, but I suppose that would have to be the sort of case that was being run. I suppose my fundamental point about this is that if the whole difficulty with the case is explained by the fact that really the objective is was never to ensure that proper legal advice, better legal advice, on the learned friend's case, acceptable legal advice was given. The target is actually detention, to get the entire detention declared unlawful, and it's logically very difficult to see how that can be done in circumstances where the Secretary of State is exercising the detention power in circumstances where she knows that people who are people who become detained individuals at the IRC will be entitled to the provision of legal advice free of charge that Parliament has said ought to be provided, and there is no challenge to the method by which that's being done.
But that's the point. If you don't challenge A, what I'm putting to you is, can you then logically challenge B? Which seems, I think that's what your submission is. And,
yes, and I think probably essentially the answer is no. You can't really logically challenge B. But it's, I mean, one can. It's not perhaps very helpful. But one can think of other analogies of circumstances where it's not to do with legal aid necessarily. My friend talked yesterday about what if people were detained on an oil rig and so on and so forth. But fundamentally, if one's looking at this in a more objective way than simply seeing whether or not it's possible to establish that the detention itself was unlawful, one would expect that one would go first to the thing that was alleged to be wrong and tackle that. And if that's not done, it is logically, I submit, rather difficult to see how one can say, nevertheless, the detention is unlawful. But perhaps I'm getting slightly ahead of myself, my lord. But I think that's the answer that I would give to that question. But the starting point, if I deal first of all with the legal basis for the claim, the starting point, of course, is that nobody disputes that the Secretary of State has an express general power to detain persons, or that the claimant was herself a person whom the Secretary of State, in respect of whom the Secretary of State had this general power to detain, subject, of course, to the points that have been adjourned to be dealt with subsequently, to do with the particular facts of her case. And as the court will recall, what paragraph 18 of Schedule 2 to the Immigration Act says is that, and this is it's handed up separately, persons may be detained in such places as the Secretary of State may direct. So it's an unqualified power. The claim is, of course, based on the principle of legality. And although it's a very well-known, not to say celebrated passage, it's perhaps worth just, if we may, reminding ourselves of what Lord Hoffman said in the Sims case about that principle. It's page 95 in the authorities bundle behind.
95, did you say?
Page 95. I was about to say behind the tab, but I've lost my reference to where the tab was. Behind tab 8. And it's the well-known passage beginning at letter E on that page. Parliamentary sovereignty means that Parliament can, if it chooses, legislate contrary to fundamental principles of human rights. The Human Rights Act 1998 will not detract from this power. The constraints upon its exercise by Parliament are ultimately political, not legal. But the principle of legality means that Parliament must squarely confront what it's doing and accept the political cost. Fundamental rights cannot be overridden by general or ambiguous words. This is because there is too great a risk that the full implications of the unqualified meaning may have passed unnoticed in the democratic process. In the absence of express language or necessary implication to the contrary, the courts therefore presume that even the most general words were intended to be subject to the basic rights of the individual. And he goes on to point out that in this way the courts, though acknowledging the sovereignty of Parliament, apply principles of constitutionality little different from those which exist in countries where the power of the legislature is expressly limited by a constitutional document. So the essence of it is the Parliament can't override. Parliament can override fundamental rights if it wants to, but it can't do so by general or ambiguous words. It only does so if it has expressly done so or by necessary implication. And just one more brief passage on that subject, if I may. This doesn't seem to have made its way into the authorities bundle, but I don't think that matters because the relevant bit was quoted in one of the documents that we put before the court, I think in our detailed grounds of defence. It's page 208 in the core bundle.
What case is it, just for my...
It's not a case. It's an extrajudicial bit of writing by Lord Sales. From an article in the Statute Law Review.
Sorry, so core bundle,
Paper.
can you give me the
Core
reference?
bundle, page 208.
208, thank you.
It's para 30 of our detailed grounds of defence. Lord Sales, writing extrajudicially, emphasising the principle of legality derives from presumed legislative intent. And then perhaps I can just invite the court to read that italicised passage.
And just looking at your article, I mean, the following paragraph goes some way to answering the oil rig proposition.
Yes.
If face-to-face access is part of the requirement of, quotes, access to justice.
Yes. I mean, this is... Yes.
Which
this is
will focus on one of the other issues flying around in this case. Whichever end of the telescope you look at it from, whether it's detention or provision of legal aid, the question is, what do you mean by access to effective legal advice? Which is the question of whether access, in the way you use it in paragraph 31, can encompass remote access.
Yes, well, I think that's right, my lord. But at any rate, this is the reason I take the court to these passages is just to illustrate that this is really the context in which we speak in here of common law rights. It's not as it were something which is independently justiciable or enforceable in all circumstances. It's the relevant question is for the purposes of construing a statute which confers a general power. To what things is that statute implicitly subject, except to the extent the statute expressly or by necessary implication overrides them? And the various cases that the court's been shown are all, of course, examples of that principle. Most of them are examples of that principle in operation. So,
for example, the common law right of access to a lawyer or the ability to communicate with a lawyer seems to be one such right which can inform the interpretation of a statute.
yes, so for example, the prison rules contained, on the face of it, an unlimited power to make regulations for the administration of a prison. But the court said that doesn't, by necessary implication, that doesn't extend to making rules preventing a prisoner from going to court. And likewise, the power to set court fees in the Whittam case, or the power to set employment tribunal fees in the Unison case, is on its face general and unlimited. The Secretary of State may make regulations, I'm not paraphrasing, but I know this is what it says, everyone looked it up, may make regulations providing for the payment of fees, and by necessary implication, that doesn't permit the Secretary of State to make regulations that impair the ability of people to get to court, to have their rights or possible rights investigated by courts. And similarly, in the FB case that you were shown yesterday, which was the one about the accelerated scheme for removal of individuals liable to removal from the United Kingdom, the general power to devise policies for the removal of individuals liable to removal doesn't extend to, though on its face unlimited, doesn't extend to doing so in such a way that they can't get to a lawyer before they're removed. And one can think of all sorts of other
But it could have done that.
We don't need to
Mr. Rowe,
labour it.
The legislation, Parliament could have gone further. The point is that if Parliament wants to
Yes.
impair some of these fundamental rights, then it has to do that very clearly in terms.
Yes, that's right. I mean, just the risk of over-egging the point, a further example might be, for example, a taxation statute that might say in general terms the taxpayer must disclose all relevant documents. It doesn't say anything about legal professional privilege. Has Parliament intended to require privileged documents to be produced? Plainly not. So the reason I mention this is because it's to make the point that in order to get home in the present case, what the claimant has to show, in my submission, is that the general statutory power to detain at a place of the Secretary of State's choosing is subject to an implicit limitation. And then we need to look at what that implicit limitation is. Now, of course, one could couch it at a very general level and say, well, implicitly, it mustn't be done at a place where it's inherent in that place that the person, the individual detained, won't get some fundamental right. I mean, it could be access to justice, which is this case. It could be some other fundamental right. And one could imagine cases where complaints might be made about other fundamental rights that were impaired by virtue of the place. But one needs to identify what is it that's being said really about about what one should take the statute as saying. Just as in my taxation example, one says, well, by necessary implication, the statute is exempting from the obligation to disclose documents that the common law would regard as non-disclosable, unless Parliament actually overrides that, which it can do if it really wants to. So in the present case, one needs to ask, what is it that by implication one ought to see in the statute? And we attempted in the courts below to articulate that. Could I just take the court to that? It's page.
Just before you leave this page, I do just want to try and make sure that I identify a point which I'd like you to deal with, not now, at some point, but it comes out of your paragraph 31.
Yeah.
Which I think is in danger of confusing two things. Because if you look at what is there, the Secretary of State naturally accepts that Parliament, when Parliament authorised her to detain relevant people in such places as she may direct, it did not intend to authorise her to detain them in a place to which lawyers, quote, had no access. Now those words are ambiguous. And you go on to say, this is because it is uncontroversial that the ability to communicate with one's lawyers is a civil liberty that Parliament could not have intended to take away other than with express words. Underlying that is the question, which I think is critical to this. Is there you accept that there is a common law right, or a civil liberty as you there describe, to communicate with your lawyer? That's the common law right, which we saw infringed, for example, in the case where the prison governor was allowed to read letters, or indeed to stop letters.
Yes, there was one case where the complaint about the prison governor to the court was intercepted and never got to the court.
The question is whether the common law right is to communicate with your lawyer, and whether common law moves with the times. And in the modern times, the right to communicate can be done remotely, because we can now communicate with lawyers remotely. And one of the questions you need to answer, as well as the question of has the right been taken away by express words, is just what is this right of access,
yes,
quotes, access to justice, or ability to have an effective communication with your lawyer. And at some point, I think you hopefully are going to address that sort of
yes.
question.
Well, I am. I mean,
square on.
It won't come as any surprise to the court that our submission will be that providing facilities to communicate via electronic means is not an infringement of the civil liberty to communicate with your lawyer. But let me, if I can answer that, I think what I was about to come on to in any event starts to provide an answer to this point. It's page 163 in the core bundle, which which document precisely this was doesn't really matter. I think it was our Scudder's argument in the court below. Yeah. 162 and 163. Bottom of page 162 is where it starts. Because what we say effectively is that there's on the claimant's case, there's a sort of implicit proviso to paragraph 18. And we set out that implicit proviso at the top of the next page, top of page 163. Provided that no woman may be detained at any site unless the arrangement as regards legal advice is that she is offered at public expense a 30-minute consultation with a lawyer who personally visits the site for this purpose. Now, one could, I suppose, quibble about the precise form of drafting of that. The 30 minutes, of course, comes from the established scheme. But that's an important part of the background. I think we both agree about that. But it's what's important for our purposes is that Parliament has decided that, Parliament, which of course is responsible for deciding how much public money is spent on this and how it should be done, has decided that that's the way that the scheme ought to work. That there ought to be, obviously this is in general terms, not limited to this particular site, a 30-minute initial consultation. My learned friend would say, of course, well, this is offered at public expense. It misses the point because he would say it doesn't have to be a public expense. It could be a pro bono scheme, for example. But perhaps the critical point is offered at no charge to the
Free at the point of service.
Yes, free at the point of service to the detainee, to the detained individual, I should say. But fundamentally, in our submission, that's what's really being said here, and that's a more helpful way of looking at it in my submission than simply saying, well, provided that you don't infringe the right of access to justice, because it's common ground that set at that level of generality, the Immigration Act 1971 did not empower the Secretary of State to infringe people's rights of access to justice. That's not very helpful for the purposes of deciding the answer to this appeal. What one needs to know is what does one mean by that, and in our submission, that essentially what the claimants below and the appellant now must be saying is essentially something along the lines of our proposed proviso. It is implicit. Says the appellant that no woman may be detained at any site. I think, in fact, my own friend went further and said no person at all may be detained at any site unless the arrangement is that they get, at no expense to them, legal advice from a person who visits the site.
No, I don't think he does. I don't think he does. And this is another link in Mr. Goodman's chain, if I can put his argument that way. I don't think Mr. Goodman would say that it would be unlawful to detain a person without providing at public expense a 30-minute consultation with a lawyer face-to-face. Because I think part of his case is that it's only women who are vulnerable in the ways that he described.
Well,
that require face-to-face. Because when you say any person, I don't think Mr. Goodman says that the same arguments would require the provision of exactly the same face-to-face services in every male detention facility.
Well,
I didn't get that to be part of his argument. I mean, he took us at great length through the evidence on the particular vulnerability of women.
I agree, my lord. That's certainly the way the argument was put. What I've just said, I picked up from my learned friend's answer to a question from my lord, which I thought elicited the answer: any person actually has to be provided. But I agree. Certainly, the argument, undoubtedly, I completely accept, is all directed towards what is said to be the particular vulnerability of women,
A particular class of women.
and indeed a particular class of women. Yes, but. Irrespective of whether I'm right or wrong in how I characterise my own friend's argument, what one gets to is that certainly as regards detention at Derwentsside, the claimant's case has to be that there's an implicit limitation on the power to detain, and that the power to detain doesn't arise in the first place unless the arrangement as regards legal advice is along the lines that we set out in our note. Now, my lord, I would submit with a statute as with a contract, there are logically two possible ways of getting to a conclusion that some words need to be implied into an instrument. One is by implication as a matter of law, and the other is by implication as a matter of fact. And our submission is that neither route gets the appellant to where she wants to get to in the present case. And of course, in the case of the latter route, implication as a matter of fact, the appellant faces the further hurdle that the judge has already made findings of fact, which therefore need to be displaced if that route is to get anywhere. And just to expand a little what I mean by these two possible routes, my point is that if one is going to say, as in my submission one needs to say in order to get home on this argument, that the Immigration Act is subject to this implicit proviso, then one either needs to show the court case law that says that is what the courts have said this instrument has as its necessary implication, or one needs to say on the facts, there's no case law saying that, but on the facts of the case, I can show that that is the necessary implication. And in our submission, neither get that. Now, so far as the first aspect is concerned, the law, and it's true, I'll come back to this in a minute, but it's true to say, I don't think my learned friend puts it as high as saying he can show you any case where a court has said on these sort of facts a right to face-to-face advice is required. But it's nevertheless helpful to look at the case law a bit and see why that can't be said. But I should just enter this slight caveat. In our skeleton argument, my lord, we address the question, and this relates to our respondent's notice, we address the question of whether there is or could be a common law right to face-to-face legal aid advice. In other words, face-to-face advice at no cost to the person being given the advice. A right in the sense that I've been talking about, a right such that it would qualify other general statutory provisions. And we do stand by the proposition that there isn't any such common law right to face legal aid advice. Along the way, I think we go so far at one point to say that the appellant hadn't established the common law imposes a positive obligation to provide any legal advice. Still less, we go on to say that it demands that it be provided face to face. I just want to be clear that insofar as it might be read as a submission that we're asking the court to rule out the possibility of the common law ever saying that somebody could have a right to legal advice, that would be to go too far. And we don't need to do that for the purposes of this hearing, and it wouldn't be appropriate in our respectful submission for the court to address the matter in such broad and absolutist terms. So I just wanted to make that clear. It's no part of our case to persuade the court to rule in or out the possibility of the common law in some situations requiring the provision of at least some legal advice.
Well, the judge ruled it in, didn't she? She said that was part of the common law package.
Yeah, yes. Well, the judge. Well, it's not. I'll come to it in a moment when I look at the judge's judgment. It's not quite clear what we would submit. What the judge said. She talked about the common law having moved on.
Well, perhaps come to, as I read it, I took it as a clear indication that she just wasn't with you on your more extreme point, that the common law didn't envisage or encompass any form of access to legal advice. That may be what she was saying, and I think for present purposes, insofar as she was dealing with the extreme point, as leadership puts it, then I don't seek to push the court back to that extent. It's what matters for present purposes, of course, is whether there is anything in the case law which compels the conclusion that the plethora of common law rights that exist for the purposes of the legality principle include a right to have face-to-face legal advice.
I understand the point about the common law not requiring face-to-face legal advice, and that's one of the questions about whether the common law now would accept, for example, your right can be satisfied by remote means. But can we just be specific? Is the common law right to have legal advice in certain circumstances, or is the common law right not to have your right to seek advice from a lawyer interfered with? Can we just be very specific what you say what common law right you do accept exists? Is it, as I say, not to have contact with a lawyer interfered with, or is it to actually have legal advice provided to you by the state?
Well, my lord, that's the as always, your lordship is a little bit ahead of me. That's where I'm going. Right?
Okay,
No, but since you raised the point, I can give a straight answer to your question. Of course, we accept that the common law right in this sense, in other words, as I've said, such that it might qualify an otherwise general statute. Of course, we accept that the common law right encompasses not having the state interfere with your ability to communicate with your own lawyer, or to have access to the courts, as in the prison case where the governor stopped the writ from ever getting to the court. The broader question as to the extent to which there is a common law right to be provided with advice free of charge by the state, whether that's by the state paying lawyers to give it, or the state setting up some scheme where they do it for free, whatever it might be, that broader question, in a general sense, doesn't need to be resolved in this case. There's not much on the authorities to suggest that there is. There doesn't seem to have been a case that decides that there is such a right. And all I'm intending to say about that is that I don't ask the court to rule that broader possibility in or out. What we're concerned with is face-to-face advice. Can one go so far as to say that the common law shows either what? Can one go so far as to show? Can the appellant go so far as to show that there is a right, either based on the existing case law or on the facts of this case, that this court should effectively declare to exist, to face-to-face communication with your lawyer, and to that extent, it is face-to-face communication at public expense, or at no charge to the person detained. Because when, as your lordship of course know, we're not concerned with the case. My friend accepted this. We're not concerned with the situation where somebody who happened to be well off was put into detention, and the partner from Freshfields turned up and wasn't admitted to the removal centre. We're concerned with the question of what is being provided to people who are in detention. So, so far as the cases are concerned, as I've already said, there are no cases that show that there is such a right. And in fairness to my own friend, I don't think that's what's being suggested. But it's perhaps worth considering briefly why that is. And it is helpful in our submission to notice what all of the principle of legality cases seem to have in common. And one thing that they have in common is that they're all concerned with some positive act to prevent a person from doing that which they otherwise would have done. And I've mentioned some of them already. They're the ones that my learned friend took the court to yesterday. Which is to say, I think it was Anderson about the simultaneous ventilation rule in prison, Unison about employment tribunal fees, and FB about the accelerated removal process. But the other cases are to the same effect, if we can just look at them very briefly. Honey, which is tab 3, page 9 of the bundle, that was the one about, I've already mentioned this, about the governor of the prison actually stopping documents being sent to the Crown Office by the prisoner who wanted to bring a claim against him in the Crown Office. Leach, which is at page 37, ex parte Leach. That was the one about censoring prisoners' correspondence. In that case, correspondence with solicitor. I think these are all fairly well-known cases, and I won't spend a lot of time going through them unless the court wants me to, but perhaps we can see from the head note if I go through, so I'm rushing them, no doubt someone will please stop me and we can look at it in more detail, but I just want the headline point really, what the case was about. Witham, which is 55, that was the Lord Chancellor removing a remission in the case of financial hardship from the obligation to pay court fees. So effectively imposing a court fee on everybody, including indigent litigants. Sims, which is 79, we've already looked at the passage from Lord Hoffman's speech in that case, but what that case was about was stopping prisoners speaking to journalists who were investigating the safety of their convictions. That's Sims, page 79. And then finally, in this little run of cases, Daly. Which is another case about communication through correspondence, I think, with a legal advisor.
Can you give us the page number?
Yes, of course, that's page 111.
Thank you. And so, if the factual basis for this case had been that the Secretary of State had prohibited face-to-face communication, that could arguably come within those line of cases.
Yes. Because that would have involved the Secretary of State stopping somebody from doing something that they otherwise would have done.
So the lawyer's at the door and is refused admission.
Yeah.
And is told you've got to do it by video conference. In the absence of a pandemic, that's not acceptable. It's quite
well. I mean, I don't
it's
want
quite
to...
striking that during the pandemic, all consultations effectively were remote, which raises the question whether there was a wholesale denial of the common law right of access during the pandemic. I suppose there might be some theorists who would say that's exactly what was happening, but
well, I suspect one can think of certain prominent people. Some of them,
I don't think we need to go down this line any further.
quite. Some would have said so, but that's as you say, we don't need to go there. We're only concerned for the purposes of this discussion about arguability of claims. I don't think I need to make any concession as to what the proper analysis would have been in relation to any such claim, or indeed what the proper analysis would be in relation to, I suppose, even a claim of where what happened was the Secretary of State prohibiting entry to a lawyer who had come to speak in person. On the face of it, one could well see why that might be said to be an infringement of the right to access to justice. But
what I was driving at.
yeah, that's the point. But I mean, although it would depend. It would depend on the reasons. If one's thinking of sensible analogies, there probably be some reason for it, and that would depend on that reason, and what the alternative was that was being provided. But the essence, as I say, is that none of these cases concern a complaint that the state has not provided a particular service to the plaintiff or claimant.
But the trouble is the use of the expression access to justice masks. It's a badge, it's a label, but it masks the real question, which is everybody accepts, I think, that you can't interfere with somebody consulting with their lawyer, if I can put it that way. These are cases where somebody already has somebody on board that they wish to consult, and the cases talk about you can't interfere with that communication, access to your lawyer in that sense. What they're really not grappling with, I think, is the question about whether the state has to provide a lawyer or pay for a lawyer.
Face to face.
Well, certainly not grappling with the face-to-face question, that's right, but not actually grappling with even the underlying question, which is, does the state actually have an obligation to provide legal advice to people in certain circumstances? I mean, it's very easy to talk, you see, about the denial of access where you've got two people who want to communicate, And we got somewhere near that yesterday when we were debating one of the examples, which was, let's assume you've got somebody who is detained at Yarl's Wood and does already have a lawyer on the job, if we can put it that way. If they were relocated to an oil rig, is that an interference with their right to communicate with their lawyer? Or I think the bottom of a coal mine was the other one, which was even more draconian. And most people would accept, I think, that certainly the coal mine example, where there's no remote signal, would be an interference with the right to speak to the lawyer which you already have on the case. But I don't think that's the basis on which this current case has been decided or argued. This is on the basis that the people relocated or located for the first time at Derwentsside had to be provided with access to a new lawyer, face-to-face, paid for by the state.
Yes. And my submission essentially is that the proposition that a statutory power to detain must be read as subject to an implicit limitation to the effect that the power doesn't apply at all unless its exercise is accompanied by the provision of a particular thing to the detained individual, in this case a lawyer, at public expense or at any rate at no expense to the individual. That is altogether a more ambitious submission, and it's not surprising therefore that there haven't been any cases in which that's been the analysis.
I think the way you've just put it, have I got this down correctly? The suggestion is that the power to detain, which is stated quite generally, is subject to an implied limitation that the detainee will be provided with face-to-face legal advice as opposed to telephone or video.
That's the claimant's.
That's your characterisation of the case.
Characterise the claimant's case. Yes.
Yeah.
And that's why I submit that it's not surprising there haven't been any cases where that's been the analysis. Which is not to say that there haven't been some cases about legal aid and the lawfulness or otherwise of decisions made within the scope of the legal aid scheme by those in charge of its operation. But that's quite a different thing from the proposition in the present case. Mm-hmm. And that leads me on really to the other point that I wanted to make about the cases. In each of the cases that we've looked at under the principle of legality, the target has been the particular rule that was directly related to the thing complained of. So in the prison cases, the focus was on whether the rules for the administration of prisons permitted the interference that was said to be was taking place on the court's findings with access to justice. But it wasn't on any prior point as to whether that somehow vitiated the power to incarcerate the relevant plaintiffs. And similarly, in the FB case, the focus is on about removals. It's about the particular scheme for removal. It's not an attack on the anterior power to remove. And what we respectfully submit about that is that it simply doesn't follow that because a person was deprived of something in detention, even if for the purposes of this argument we accept, which obviously we don't, that the thing in question was something to which the person was entitled as a matter of law, it doesn't follow that because a person was deprived of that thing while in detention, that the detention itself is unlawful. This comes back to my opening point about my second of my two opening points about the target of the claim.
But it could do. I mean, are you saying it could never, as a matter of concept? I mean, I'd take the coal mine example. I mean, if somebody has a lawyer who they have instructed on a case and they are detained in a place which it is impossible, where it is impossible for them to communicate with their lawyer by any means, are you saying that it still can't be an unlawful detention? That's quite a...
No, no, your lordship's right to point. Of course, one can always illustrate why it's perhaps unwise to say never, and that might be an instance.
But you were making a logical point. You were making a logical point to say that because you detain somebody and don't provide them with something, I thought you were saying logically it doesn't invalidate the detention, the anterior detention.
It depends upon.
And I'm saying I'm not sure that's right.
The distinction. The distinction is, I think I would submit, between a case where it's inherent in the it's absolutely inherent in what you're doing that you're going to be depriving, and it's properly analysed. It's really part of the detention itself that you're depriving the person of the relevant thing, as in the coal mine example, and a case where the fairer analysis, or the more objectively the normal analysis of it is that you've got a detention which is lawful, but that there is something which occurs in the course of the detention or doesn't occur. In other words, one can't.
It could.
If I could reformulate it this way, I have to accept, of course, your lordship's right to say I can't say one can never reason back from some aspect of the circumstances of the detention to say therefore the detention was unlawful. But it depends upon really whether it's inherent in what you're doing or whether it's properly analysed, it's some feature.
It may need to go further than that. One could see that if the person was put down the coal mine with the intention of depriving them of access to justice, that could vitiate the decision to detain them, because it would be taken on unlawful grounds or unlawful reasons.
Yes.
But if that's not the case, and it is simply a fact that I needn't go down a coal mine, but might be somewhere which had no coverage or something like that, then the target and the breach of duty would be not in detaining the person, but in depriving the person of access to justice. So you're probably right to back away from never, on the basis of one should never say never, because it'll come back next week. But my first reaction is that you need more than simply the fact of detaining in circumstances where there is a breach of the obligation to provide access to justice.
Yes.
Before one vitiates the detention itself.
Yes.
Which is getting a bit close to this case.
Well, yes. And the reason one needs that is because the thing that one objects to could be remedied in lots of different ways.
Yes. Well, the coal mine,
I mean, that's an extreme
quite lots of objectionable about detaining immigration detainees in coal mines, but we're using it as an extreme example, as a sort of proxy for
yes,
anywhere which does not have access. And so it seems to me that it comes back to, if you take out the extreme language, we come back to where we were a few minutes ago, which is that you accept that to detain someone and then to prohibit access to face-to-face lawyer who's there, ready, willing, and thinks it's necessary, would be a breach.
Yes. Well, that would be
of the obligation not to impede access to justice.
It would, but it would be a breach remediable. Well, how would the court address it?
By letting in the lawyer.
The court would probably make an order requiring the order to be let in.
Yes.
And I suppose the court might say, if you want to continue to detain, you've got to let the lawyer in. But nevertheless, the focus would be on letting the lawyer in. There's a paragraph in FB, which in the judgment of the Lord Chief Justice, which might be relevant to Lord Justice Snowden's question. It's page 453 in the authorities bundle. It's paragraph 185.
185.
185.
Thank you.
A challenge to a policy. Your Lordship has that. Challenge to a policy or statutory instrument on the grounds that it deprives those affected by it of a realistic opportunity to challenge an adverse decision and thus deprives them of effective access to justice. Must demonstrate not a theoretical impediment but something more concrete. And then this is the bit that might be relevant to the exchange we just had. The vice must result from something inherent in the policy itself rather than its aberrant application. It's not quite on point, but the coal mine example, it's inherent in the very act that you will deprive people of communication with the outside world. Here we're miles away from that. So
it's quite a difficult. I have to say that it's an interesting but quite difficult test. Suppose the Secretary of State decided to detain people in a facility where there was no medical facilities at all on site. It was just a secure detention facility with no medical facilities at all. Is that an unlawful detention on the basis that you can see that you detain large numbers of people, they're going to need access to medical assistance, or they might. There's a real risk. Or do you say, no, that can be addressed because if there is a medical emergency, we will allow medics to come in from outside?
Well,
it's quite a difficult test.
Yes, it is. It's quite difficult to debate these things in the abstract because, of course, the way that the common law actually works, or the way that principles of statutory interpretation actually work, is by reference to specific examples that arise on particular cases. And I suppose it's quite elusive to try to tie down what is the yardstick by which one decides whether one is looking at a lawful detention, but with some aspect of it that gives rise to a complaint, which can be remedied by that aspect being put right. And on the other hand, a detention which is simply inherently unlawful, and it depends on the facts, and which is why the putting people at the bottom of a coal mine is is an easy example at one end of the spectrum.
But we are getting really to the heart of the sort of logical or intellectual sort of question here, because there is a real question about whether this is, in essence, an attack on an unlawful detention, or whether it's an attack on the failure to provide legal aid. I mean, that's
yes.
This is what we're debating, which is really quite central to the way you might look at this case.
Yes, it is. And well, it may be that the search for a precise formulation by which one can answer which of those it is a tricky one, and perhaps ultimately fruitless. But one can generally, in most of these examples, one might have thought, come to a view one way or the other on the basis of simply what is the normal, sensible way of rationalising what's really going on here. And that what's peculiar about this case is that as we submit, is that and it derives from the way in which the claim is brought, and possibly that's not for us to say, perhaps the motives of those who brought the claim. What's peculiar about the claim is that it's targeted at saying that detention at this centre is unlawful in toto. Whereas, as I said at the outset, one might have thought the more natural target of the complaint was the respect in which the provision was being given. Of course, the difficulty with that second way of doing it is that one then runs up against the fact, the claimants would then run up against the fact that there is a scheme for the provision of legal advice in LASPO, And that's actually quite prescriptive in the sense that it says in terms that the person receiving the advice isn't entitled to decide in what form it should be received, and that the advice can be provided by remote means.
But you can answer the question if you ask it this way, can't you? That if the common law right is limited to non-interference with access to a lawyer, then this detention was lawful because there was no prohibition upon face-to-face consultation or indeed anything else. And the complaint is then on a failure to supply a particular type of legal assistance, which is a complaint about the provision of legal aid, which falls into that category. If, however, the common law right, is more extensive, then the detention they couldn't vindicate that common law right would be a criticism of the detention. So doesn't it come back again to this focus on just what is the extent of the common law right? Is it to lack non-interference, or is it to positive supply?
My Lord, it does. I mean, I suppose it does. For my purposes, I think I need, however, go no further than to say that whatever precisely the ambit of the common law right is, it is not a right to face-to-face legal advice. And that's sufficient for my purposes, and the court needn't. If the court agrees with that proposition, then it, and or if the court agrees with the proposition that even if it might be in some circumstances, it isn't in this case, then that's sufficient for our purposes. And the court doesn't need to go further, whether to rule in or to rule out the possibility that in other cases, on other sets of facts, the common law might say that there is an obligation on the state to provide legal advice. So, my lords and my lady, that's if you recall, the scheme I was working down was that, if I'm right, that the way of looking at this is to say what should be implied into the, by way of proviso, into the detention power. That's really what I say about the proposition, insofar as it might be thought to take the claimants anywhere, that the case law establishes any sort of right to what's being asked for here, or what's being, the right to that whose absence here is said to result in the detention being unlawful. It doesn't work as a matter of case law. But the other aspect, of course, is what about the facts that were actually before the learned judge and now before the court? Do those facts actually support the claimant's case? And the way I'd put that, my lord, is to say really this, that, and perhaps it's a statement of the obvious, but we perhaps can we need to sort of draw together where we got to so far. On the appellant's case, it needs to be shown that face-to-face contact between a detained individual and a lawyer is so important that its absence means that a person has been deprived of access to justice. It's not enough that it might be preferable, desirable.
But we are talking about real risk, aren't we? So don't we need to, the applicant needs to show that face-to-face is so important that its absence means that there's a real risk that the person has been deprived. A real risk in the real world.
Yes, I think I'd accept that, my lady. A real risk in the real world, with in relation to at least a significant number of detained individuals.
But we've only got one, so.
Yeah, we've only got. Well, we've got a rather strange.
Yeah. So I don't want to distract you on that. I just wanted to get the test right.
No, quite. Thank you. I much prefer to be stopped and told to make clear what I'm saying, rather than allowed to go on with it unclear. No, I think I'd accept that. But the key to it again has got to be that on the evidence, it's got to be shown that I accept it's about real risk, but but it follows from that. It's got to be shown that in at least some cases there will be a situation where the fact that what's on offer is telephone advice or video conferencing means that the person has been deprived of access to justice, which is not the same thing, of course, as the person being deprived of that mode of access to justice that they would prefer. Now, it's just before I do get onto the facts, it is of course relevant in that context to note that, as I've already mentioned, that Parliament has, to some extent, already turned its mind to the question, as regards legal aid, as to what one ought to be entitled to, and that's all in the authorities bundle. If one looks at page 7. Which is section 27 of the last bill. Now, I know my learned friend says, well, this has nothing to do with it, because our complaint is about detention, and it's not our problem, essentially, and I'm paraphrasing, of course, but it's not our problem how the Secretary of State deals with it. The fact is the Secretary of State mustn't detain unless there is what we say is sufficient legal advice being provided. And it could be done by some other method, for example, pro bono. But in the real world, this is how legal aid, this is how legal advice that's free at the point of the advice being given is provided. And what's relevant to my submission is that we can see that here Parliament has addressed its mind to this question, obviously not in the specific context of a person who's detained, but just in general. But it has addressed its mind to the question of how the Lord Chancellor shall perform the overall duty. The overall duty is to secure that legal aid is made available in accordance with this part. That's just skipping up to page 5, that's section 1. Section 1.1 specifically. Section 2.1 gives the Lord Chancellor a broad discretion, may make such arrangements as the Lord Chancellor considers appropriate for the purposes of carrying out the Lord Chancellor's functions under this part. And then, as I say, section 27, expressly making clear that the duty, subsection 1, does not include a duty to secure that where services are made available to an individual under this part, they are made available by the means selected by the individual.
And I was just looking at the judgment. Forgive me, this may not be quite the absolute point. And the judgment recounts SPM's progress, particularly if one looks at the position after the 4th of February when she was referred to Duncan Lewis, paragraph 21. And Ms. Parrott did make an appointment to see SPM face-to-face, but that was cancelled because she was moved back to Derwentsside without prior notice.
Yes.
Which, on all of the evidence, suggests to me that that was a distance problem rather than anything else. It wasn't a prohibition of face-to-face.
Yes.
And those sort of things, like a peremptory removal from one place to another, are typically the sort of thing that would lead to a challenge to the validity of those decisions. I think that would be right, wouldn't it? If someone objected to the fact they hadn't had a face-to-face because they had been moved or because they had been for some other reason.
Yes,
the complaint would naturally be about that limited feature.
yes. One would either say, well, it would depend on how it was dealt with, but one would complain I shouldn't have been moved when I had an appointment to see my lawyer at Centre A and you've moved me without notice to Centre B. I want an order to either move me back to Centre A or making arrangements for me to have remote communication. I mean, this presupposes that you can say that remote communication isn't good enough.
Yep.
That would raise itself another issue.
Yeah.
But what
Sorry,
would
I
be-
interrupted your flow.
No, not at all. It's gives me an opportunity perhaps to underscore my point that what one wouldn't say in those circumstances is, well, my detention is itself unlawful. It would be about the arrangements of the detention. But I was looking at section 27 because that's of course Parliament's general provision about how legal aid in general is provided, and I mentioned subsection 1, subsection 2. The Lord Chancellor may discharge that duty in particular by arranging for the service to be provided by telephone or by other electronic means. What that underscores, I accept of course that that's not directed to any particular context, it's just legal aid in general. But it does rather underscore the point in my submission that if the court is going to say, or was contemplating saying, that the common law right for the purposes of the principle of legality goes as far as to require the provision of legal services face to face, then it ought to have some pretty compelling material to lead it to that conclusion.
Why? Because that would swim against section 27(2.
Yes. At least be in tension with section 27(2). I mean, section 27(2) doesn't, of course, say this shall invariably be the case, and the Lord Chancellor may never or need never depart from it. It's still about the Lord Chancellor's power, what the Lord Chancellor may do. But it makes clear that in itself, by itself, the fact that legal aid is provided by telephone or other electronic means cannot be objectionable, cannot be criticised in it as a breach of the Lord Chancellor's duties under the statute. I don't invite the court really to speculate about possible cases in which things might be said differently. But it's a pretty ambitious submission, in my submission, to say that in the face of that, if one was challenging the Lord Chancellor's exercise of his powers, one could ever say, well, it's not a proper exercise of his discretion under that statute if he refuses to provide in-person advice. But for present purposes, I think all I need to say is that one would need some very compelling evidence to show that the inadequacy on particular facts of anything other than face-to-face advice. And in my submission, the class of cases in which one really could say that the common law would ever say that there is an obligation to give face-to-face advice, the common law, for the purposes of the principle of legality, is vanishingly small. Now, the court was taken with great care by my learned friend yesterday through all of the material on which the appellant replies in the evidence. And as I said earlier, I don't propose to repeat the exercise. Your Lordships and your Ladyship have the material and can form a view on it based on your own assessment of it. What I do ask the court to note is that...
Sorry, just to be... you need to tread quite carefully here. It's quite a controversial area as to the extent to which a court is entitled to disregard expert evidence, which is not challenged. I mean, that's split this court in recent years.
Yes.
I don't mean this court. I mean the Court of Appeal in recent times has differed on the question of whether a court is entitled to disregard of its own motion expert evidence, which is not challenged
Or by contrary evidence.
by contrary evidence. That's quite a controversial area, and it's I don't know where we currently are with that, whether the Supreme Court has actually taken the appeal or whether it hasn't, but are you suggesting that this court, or indeed the judge more particularly, was entitled to say, well, I see all that expert evidence that says it is, quote, essential, where you are dealing with a vulnerable woman, to have a face-to-face meeting, because without that, the fact that she may have been trafficked, for example, just simply won't be discovered. Are you saying that this court could just say, well, it's not very persuasive, or I don't think it's right, or what? I really have some problems with that.
On the authorities, as things stand, as I understand, though I can certainly double check.
I can't remember the name of the case. The case
It's Griffiths and Tewey, I think you may be thinking of.
It's the case on.
It
was it some motor claim? No, I can't remember what sort of claim it was, but
I think Griffiths and Tewey. Griffiths and Tewey was a
yeah,
travel law, as it were, claim. It was somebody who had an accident abroad, I think.
yeah. There's certainly been.
What your lordship may also have in mind, your lordship's judgment a year ago in the case of Volpe and Volpe, agreeing with Lord Justice Lewison about the principles on which one looks at appellate decisions on on which an appellate court looks at first instance decisions on fact. That mentions the Griffiths decision and says in terms, even where expert evidence is uncontroverted, a trial judge is not bound to accept it. See Griffiths and Tewey.
Yeah.
But I can say on that what the position is as regards any onward appeal in Griffiths and Tewey.
Yeah.
Not least because counsel in one of the cases is a colleague of mine, so I'll be able to get that fairly quickly, I would have thought.
I do just know it's a decision which has been greeted with a certain amount of debate, shall we say?
Yes.
And certainly it was a split decision, I think.
It was a split decision, but that's as your lordship knows, that's immaterial for the purposes of precedent, of course.
Yeah, of course.
No weaker a decision if it's 2-1 than if it's 3-0. But what I say about this material, I do say, if I need to, that the judge was perfectly entitled to not to accept the expert evidence insofar as it was expert evidence. I say insofar as it was expert evidence because a lot of what your lordships and your ladyship was shown yesterday consisted of statements by variously by the claimant's own solicitors about their experience in general, or by Dr. Loosely, who is herself a member of the then first claimant, Women for Women Refugees. She's their policy and coordination officer. So one kept hearing Doctor this and Doctor that. Dr. Loosely, and I think it's right to say, has a PhD in criminology and works for Women for Women Refugees. So she wasn't put forward as an expert witness.
I think one of them was Dr. Cohen.
Yes.
Dr. Cohen provided a CPR compliant expert report.
That's right, yes. Albeit, as your lordship, I think, pointed out in the course of my friend's submissions, that some of the questions that she was being asked to deal with were leading questions. But
you didn't say...
No, I agree, and I don't... I don't need in the present, and we didn't need on the facts of this case to, for example, call for cross-examination of that witness. The Secretary of State was perfectly entitled to say, as the Secretary of State did say, and as the judge as I will say, found that the overall effect of all of that evidence is such that it doesn't get home on the central point in the present case, which is whether it can be said that the absence of face-to-face legal provision, as a matter of course, is such as to constitute deprivation of access to justice. That's a matter for the court, not for the experts. And the fact that the experts opine, and they don't all say. You'll just take them through it yesterday, and I won't go back to it. But they don't all, by all means, all say this was essential. They talk about the desirability of it. They talk about the difficulties that some of them have experienced. Some of it is set in different contexts. In the medical context, what about a lawyer? What about a person who is dealing with a medical professional? Will she open up straight away about ghastly things that have happened to her in the past, or will it take some time? And is it better to do that face to face? That's not the issue that the learned judge was faced with in the present case, which is one about access to justice. And access to justice requires that the individual be in a position to give instructions to the lawyer, that the lawyer be in a position to take instructions from the individual, and that there be a sufficient level of communication in the circumstances between them.
You say that's the central point. That there are two central points out there. One is, can it be said that the absence of face-to-face provision is a derogation from the principle of access, unimpeded access to justice? But the second is equally important, which is, if it is, does it affect the legality of the detention?
Oh yes, that's undoubtedly also my point. Yes, when I say central point, I mean just on the analysis of the factual evidence, to see the central point in seeing whether the claimant even gets into the territory of being able then to argue that the detention is unlawful. But I certainly wouldn't want to be thought to be abandoning my further point that in any event it doesn't follow that the detention itself is unlawful. But as I say, my lord, in my submission, even if the court accepts my learned friend's invitation effectively to set aside the judge's findings of fact and start again, because nobody wants this to be remitted, even if the court accepts that, then in my submission the evidence doesn't go far enough to enable this court to put that essential building block of my learned friend's case in place.
Do you say that specifically in the context of Section 27? When we looked at Section 27, you said you'd need very compelling evidence to get yourself into a position where you thought that lack of face-to-face was required. So just circling back, is Section 27 part and parcel of this argument? Because speaking for myself, I think there doesn't seem to be anything that tells us what is the minimum component of this alleged common law right. It's asserted that it requires face-to-face, but that's the very issue on this hypothesis we've got to decide. And
yes,
there doesn't seem to be very much to go on about what really amounts to the essential basics of a common law right of access to justice, of access to legal advice as a component of access to justice.
well, but lady, yes, I mean, Ladyship's with respect, right? That clearly you've got to identify what is the, well, it is insofar as it exists, is face-to-face provision. Can it be in any case such an essential component of the legal advice that its absence means that there is an absence of access to justice? What's the relevance of Section 27? Well, the relevance of Section 27 is that's Parliament's judgment, admittedly in general terms rather than directed to any particular context, but that's Parliament's judgment as to what's necessary in order to ensure that, as a general proposition, those persons who need legal advice and can't afford to pay for it themselves, and who are not in those many categories where Parliament has just said, I'm afraid that's too bad because of the nature of your legal dispute, we'll have to go and find somebody to act for you on a no-win, no-fee, or whatever it might be. That's Parliament's judgment as to people in those categories. What is it that's required in order to satisfy the the principle that they should have access to legal advice, which they can't otherwise afford to pay. And so it is, in my submission, pretty significant in that context that Parliament, having addressed its mind to the question, has said that it may be done by remote means. And of course, Parliament at the time was the other factor, which leads into what the judge said, is that in Parliament at the time says provided by telephone or other electronic means. I mean that's only 11 years ago, but of course, I no doubt if Parliament was legislating today, well, not no doubt, but quite possibly if Parliament was legislating today, it might have put things in a different order. It might have said by video conferencing or by telephone or other electronic means, because this picks up on something that what Justice Snowden said earlier. I do say that insofar as there is any common law right at play here, it's got to be informed as well by the march of technology, and the fact that, as the judge found, as I say was entitled to find, the quality nowadays of video conferencing is very high. And we're not concerned in the present case with, there's a little bit of confusion actually with respect in the grant of permission to appeal. We're not concerned in this case solely with telephone advice or with any failure to provide video advice, or with any failure by the judge to analyse the relevance of advice given over video conferencing. The evidence was quite clear, and the judge accepted it, that video conferencing facilities were available. Indeed, the judge found that, and it's not a case where anyone was saying that what you're left with is some sort of Heath Robinson system where you can, if you really must, you can do this over a laptop in a corridor somewhere. There were video conferencing suites on the evidence that were available in the place.
Forgive me for interrupting again, but 27.2,
Yes.
you interpret as meaning that Parliament has limited the extent of the duty as a matter of Parliament's decision. The duty is satisfied by electronic means rather than face-to-face.
Yes.
Well, so it equates electronic means to other means, i.e. face-to-face. Because it says it doesn't say in particular or inappropriate cases or anything like that to qualify it. It's just saying the duty is discharged if you use... That's your interpretation.
Yes, and Section 27.2 says that, and so does Section 27.1 makes it clearer by positively ruling out a duty to provide the services by the means selected by the individual.
Yeah.
Is this right? If you say, if the common law right is limited to non-interference with your ability to communicate with your lawyer of choice, there's no evidence in this case that there was such an interference, because nobody is suggesting that people couldn't come and have face-to-face consultations. There was no prohibition. There were video conferencing facilities. There were telephone conferencing facilities. So there was no interference of the type that we saw in some of the cases of stopping letters or the like.
Yeah.
You don't accept that the common law right extends to a positive obligation on the state to provide free services of a lawyer. But
Well,
you'd say, but we don't. But that's not a point that actually needs to be determined, because on any footing, the common law right, when read against Section 27.2, must have been modified by Parliament, such that the only right is to have the provision of free legal advice by services which included telephone or other electronic means, because that's what Section 27.2 says. So whichever way the common law right is, you say there's no interference with it, which would act as a fetter on the right of detention.
yes, well, that's
That's it.
essentially it.
Yeah.
Yes, as your lordship says, I don't invite the court to rule in or out as a matter of abstract principle the possibility of the common law saying in certain circumstances legal aid must or must not be provided. What's important is, as regards the present case, if there's no right on the present fact to be provided with at common law provided with any legal advice. In the sense that the detention power isn't subject to that common law right, but even if it is, it doesn't extend further than what Parliament has provided for in the Act. I hope that's a way of essentially saying yes, I agree with your lordship's formulation of what I'm saying, but I want to put it in my own words.
Well, I've written down the formulation because I thought I agreed with it, or at least I thought I recognised what was being said.
Yes, I'm only trying to make sure I understand what you're saying.
Yes.
in a way that stress that.
Yes, no, I quite understand. I didn't take it as an indication that that's what your lordship is going to conclude at the end of the day. Otherwise, I would have thrown in the towel yesterday when your lordship summarised my learned friend's case. So that's what I say about the position. If we get to the stage that the court thinks it's appropriate to and does reopen the factual issues that were before the learned judge. But of course, the final point I make in this context is that in order to get there, my learned friend has to surmount the hurdle of showing that the court can and should set aside the judge's own factual conclusions, because the judge, of course, did address this point in her judgment and did conclude that the provision of legal advice via telephone or video conference didn't amount to a denial of effective access to justice. That's paragraph 106 of the judgment. And Lord, just before I go to that, I asked my learned friend, Mr. Pennington Benson, to hand up a copy of Volpe, which is the recent case in the Court of Appeal I mentioned. Can I just ask the court if that's
We've got that on our
found
desk.
its way? Has it come into the authorities?
No, it's on the desk. It's loose.
On the desk, yes. This was a case, and I know it to be said at once, of course, that it's a very different context. So I'm not overlooking that in drawing it to the court's attention. But this is just a recent case about this court's approach to appeals on questions of fact. And as I mentioned earlier, it's a case in which one member of the present court was violated the Constitution there. And for present purposes, one can simply look at, one doesn't need to go into the particular facts of that case, one can simply look at the summary by Lord Justice Lewison in paragraph 2 and following, 2 to 5, of the law regarding appeals on questions of fact. And may I just invite the court to read those paragraphs, 2 to 5. Shall I move on, or is your lordship still looking at that?
Yep, no, sorry, I was just
Cool.
checking something else.
Quite. No, not at all. So, I say at once, of course, I accept that it will no doubt be said against me that Volpe is a case in a very, very different context. It was a 4-day action involving live evidence from witnesses and not much documentary evidence. So, of course, the task of challenging the judge's conclusions on fact arose in a rather different context. But there's no reason in my submission to think that the overall approach of this court to appeals on pure questions of fact is any different, where the context is a judge's assessment on the papers of factual questions, provided, of course, that one keeps in mind that there are some aspects of the justification for the Volpe approach, if I can call it that, that don't apply. Primarily, of course, that one can't say, well, the judge had the advantage of seeing the witnesses because there weren't any witnesses in the present case. But that's nevertheless not to detract from the proposition that the court needs to be very careful about overturning findings of fact, and I would submit even in cases such as the present. And many of
there was some authority specific in the judicial review context where you've had a lower court that's made findings on the papers. I think it heads roughly in the same direction.
Yes.
That you need to be careful about.
Yes,
It's not quite the same.
maybe right.
And how does Volpe fit with the anxious scrutiny?
That's just what I was about to come on to. And anxious scrutiny is in MN, which is the other case that I've asked to be passed up. It's not, in fact, in the authorities bundle. MN was a case about two individuals who had been through the national referral mechanism, which is concerned with identifying, as you will recall from yesterday, and may know anyway, whether they were victims of trafficking or not. And a conclusion had been drawn that they weren't, and that they raised judicial review claims about that. And it's a long judgment, but the relevant bit, I think, starts at paragraph 240. Where it said in relation to MN that her case is that the approach taken by the judge. This is an appeal to the Court of Appeal against the judge's dismissal of the judicial review. The approach taken by the judge was simply too broad brush, given the detailed challenge raised by the two grounds in question, and did not involve the kind of heightened or rigorous scrutiny appropriate to the judicial review of a decision of this character. We've heard the word anxious scrutiny. Indeed, that appears at the top of that section that we just looked at. In fact, if one looks at the footnote, one can see there are 40 footnotes to this judgment, I think, but one can see that footnote 31 explains that Mr. Hussain, who was counsel in the case, used that language rather than referring to anxious scrutiny because of the unhelpfully talismanic status that phrase has acquired and the continuing controversy about its precise effect. So I'll do the same and avoid anxious scrutiny and just say particular care. Anyway, it goes on at 242 to talk about, first of all, the starting point having to be the standard of reasoning required in the decision itself. That's to say the conclusive grounds decision. And it's clear that high quality of reasoning is required, must engage fully with the case advanced by the putative victim of trafficking. That was accepted by counsel for the Secretary of State. And the court goes on to say that's for obvious reasons. It says in the next paragraph, that's emphasised in the guidance itself. And then what's relevant for our purposes is, I think, the passage that my own friend cites, 244, over the page. In our view, it follows that on a judicial review challenge to a conclusive grounds decision, the court must likewise consider the decision with particular care. This was accepted by Sir James Eady and Mr. Irwin in their skeleton argument, citing Mr. Justice Cranston in another case. The intensity of review is high. There's cases involving Article 4 of the Convention. Important in particular to establish whether the decision maker has indeed observed Lord Justice Carnwath's injunction that every factor which tells in favour of the putative victim's case has been properly taken into account. Well, the question that then arises is, well, to what extent is MN applicable to our case? Which I think the answer I would give is, well, up to a point. Obviously, our case is concerned with actual or alleged fundamental rights, not convention rights. The claim has never been advanced on the basis of the convention, but here the common law right, whose precise nature and scope we've been debating. And to that extent, of course, MN is in point, and it's reasonable to expect that the court ought to take particular care before saying that somebody's rights haven't been complied with. But it's by no means on all fours with our case, because MN was about a specific individual's claim to be a victim of trafficking, and much of the reasoning behind the requirement for particular care, particular scrutiny, derives from that, or is set in that context. One needs to look at all of the putative reasons why the person claims to be a victim of trafficking and assess carefully whether each of those reasons is or isn't a valid reason. That doesn't translate terribly easily across into our context, in my respectful submission, albeit I accept, of course, that the as I've said, that the context of this being a claim based on fundamental rights is that the judge was, of course, obliged to look closely and carefully at whether those fundamental rights, to the extent that they're found to exist as a matter of law, had been infringed in all the circumstances. But the extent of the read across is no greater than that, in my respectful submission. And MN is not a license simply to cast aside the classic approach to the Court of Appeal takes to questions of fact. So one can't, for example, simply assume that because the judgment expresses matters briefly, proper consideration hasn't been given to all of the relevant facts. It happens that in NN that was
There's no very clear indication. There's no reasoning.
In our case.
In our case.
Yes. Well, let me
So
turn directly to our.
She sets out her summary of the relevant evidence.
Yes.
And there's no criticism of that.
No, my friend very, very fairly accepts.
But there is no point at which she says anything which adds up to. I've looked at the evidence and I don't accept it, or I only accept it to this extent, or I make the following findings for the following reasons. There's nothing.
No, my lord, I entirely accept. I can't show you anything in the judgment where the judge addresses it in that way. There's nothing where I agree. There's nothing where the judge says in terms, I've looked at the evidence, but we can see that she did look at the evidence, and indeed she recites earlier in the judgment the factual background, and she makes reference to all of the evidence that the claimants relied upon. What we have to accept that the ladyship didn't do was to go systematically through all of that evidence and set chunks of it out and say, this is what I think about this bit of it, this is what I think about this bit of it, and so on, and then draw it all together in a conclusion. She goes to the conclusion.
Well, let us be sure. We're talking about paragraph 106, aren't we?
Essentially, my lord, yes, we are.
And we're talking, in essence, about the second sentence. Well, certainly one of the issues we're talking about is the second sentence of paragraph 106. Yes?
Yes.
I mean, the judge saying, I think that video conferencing facilities are comparable to an in-person meeting. Now, the objection that's raised in relation to that is that might be okay for a hypothetical general person litigating in the courts, of which the judge might have had experience. But the evidence, at least the expert evidence that there was, said that that's otherwise for women of particular vulnerabilities or who had particular experiences. And the judge didn't grapple with that. That's the criticism, I think.
Yes, and I can't point to anything in the judgment to refute that criticism. All I can say is that what one can see is that the judge set out at some length the evidence that she had been presented with. We can see that it really picks up from paragraph 44 of the judgment onwards. And it must follow that all of that evidence was in the judge's mind. This is not a case where you can say, well, the judge appears just to have forgotten chunks of the evidence. She looked at it. She set it out in summary form. Not that summary. I mean, it takes a couple of pages. Well, it takes a bit more than a page. And so one is left with the complaint about to use the metaphor that's always used, about the failure to grapple with the evidence. But in my submission, one can't. One should be pretty cautious about concluding from that the judge didn't properly analyse the material such that this court should set aside her essential finding, because her essential finding is not made in the abstract. It's made in the context of being perfectly well aware.
But what do you say her essential finding is?
Her essential finding is that notwithstanding all of the material that she's looked at about the advantages of in-person visits to the particular cohort that we're concerned with, and the disadvantages of anything other than in-person visits, notwithstanding all of that, her conclusion is that the absence of in-person provision is not a denial of effective access to justice in real-world conditions.
I mean, all she actually says is that the quality and convenience of video conferencing is comparable to an in-person meeting.
Well, that's not quite all she says, because in the previous sentence she says in her judgment the provision of legal advice via telephone or video conference instead of in person for a limited 6-month period. I'll come back in a second to the criticism that's delivered.
Hang on, the first sentence is not a factual finding. The first sentence is a conclusion of law.
Well, I agree, my lord, but it didn't come out of nowhere, and it doesn't just come out of the second sentence. It has to be seen in the context of the whole judgment, including the recitation of all of the factual evidence.
No, but sorry, I thought this whole point of this part of your submissions was that we should defer to the factual finding of the first instance judge. I'm just saying the first sentence of 106 is not a factual finding.
Well, I would submit that it contains within it it contains within it the factual finding that the arrangements that were, I mean, you might say this is a conclusion of fact or a conclusion of law. It's a bit of both in a sense, but it contains within it the finding that the arrangements that were on offer didn't amount to a denial of effective access to justice. And what one reads within that, in my submission, that the judge had, albeit she doesn't articulate it in that sentence or elsewhere at any length, had considered the points that were being put to her in great detail and with great force about the opinions of those who have been involved in the claimant's case and in general in dealing with detained individuals about the need for in-person advice. And of course I agree that sentence doesn't read on its face as a factual finding so much as a legal conclusion. I can't deny that. But it's not right. It's not right to characterise this, in other words, as the judge then in the second sentence loading the whole of her conclusion onto the proposition that the quality and convenience of modern video conference facilities is very good and comparable to an in-person meeting, though that is clearly part of it.
Right.
briefly, since I've mentioned it, the for a limited 6-month period, I accept, of course.
I mean, but just to be clear, that second sentence is not saying that in every respect and for every person, a video conferencing meeting is comparable to an in-person meeting. She's just saying the quality and convenience is comparable. I mean, if we really get down to it, it's only actually talking about quality and convenience, and she hasn't explained her frame of reference for that.
Well,
I mean, it's a quality and convenience. It's not actually talking about the ability of the people using the facilities to do other things.
Well, my lord, I think my answer to that would have to be that what your lordship is in danger of doing is that which Mr. Justice Lewison, with your lordship's agreement, said shouldn't be done in Volpe, which is subjecting the judgment to close textual analysis.
No, but if if one is, standing back, if one is to accept your point that the court can differ from or not accept expert evidence, which was actually the issue in Volpe, because there was expert handwriting evidence that was very much at issue, and whether the trial judge had been entitled to differ from it. You have to explain why you're doing it. You know, and that's before you even get to anxious consideration or whatever the appropriate phrase is.
Well, my lord, it depends. The extent to which you have to do it depends upon the quality of the evidence that's put before you. I mean, plainly, if you're confronted with an expert report that says that I've done millions of handwriting reports and I'm confident for the following 6 reasons that this handwriting is not the testator's handwriting or whatever it might be, then that's one thing. But this is not that case. Your lordships were not shown any. I think it's right to say lordships were not shown any direct expert evidence bearing specifically on the question of whether a lawyer could deliver an adequate service to a client over video link as compared to in person.
Well, I mean,
it was all in much more general terms.
Dr. Cohen's conclusion, which we looked at, was fairly close to that, if not expressly that, wasn't it? Where she was asked the question: "Is the centre without face-to-face fit for purpose?" And it's the paragraph at 276. I mean, you know, if you are going to say that this is not, I think you've got to come off the fence here. If you're going to say that this expert evidence is not credible or should have been, capable of being disregarded because it's just not plausible expert evidence, then I think you've got to be very clear about that. I mean, it's page. I mean, for example, we were taken to paragraph 284. Which ended with the sentence, "In-person appointments are essential for safety and for access to justice," but explained why legal advice needed for vulnerable detainees was essential because for safeguarding and to assess their vulnerability and for disclosure of past experiences. I mean, obviously this built on the back of the remainder of her expert report, but are you saying that that's something that the judge was able to disregard without explaining why, or that we should not have regard to?
Well, the judge didn't disregard it. The judge.
Well, she didn't explain why she didn't accept it.
She didn't explain. She didn't explain why she didn't accept it. That much I have to accept. But it doesn't follow from that the judge disregarded it, and it doesn't. There's no basis in my submission for concluding that the judge was bound to accept it. And this was opinion evidence about. I mean, we're in quite a difficult area as regards expert evidence here, because this is the subject matter that we're concerned with is a subject matter which is actually within the court's knowledge and expertise. Relationship between lawyers and clients, and to what extent is remote communication adequate. It's not a matter upon which.
The difficulty is, I might well have a view as to the adequacy of video conferencing for the purposes of communicating with lawyers appearing in front of me or professional parties. These were not professional parties or people appearing in front of a judge.
Oh, yes. I mean, I'm making
I have no experience of acting as a lawyer for a potentially vulnerable woman who may have been the subject of trafficking.
No, I see that, my lord, and I'm making a more subtle point than saying simply well, the judge knew about conducting remote hearings, although that is an important part of the context. But equally, my point is that the expert report of Dr. Cohen is the report of she describes herself a forensic physician and fellow of the Faculty of Forensic and Legal Medicine. We're not in the territory of, I respectfully submit, of, for example, a clinical negligence case where the judge has no idea how you conduct a heart bypass and has to be taken through it by an expert, so that if the judge says that the heart bypass expert's got it wrong, the judge has got to have some really pretty good reasons for it. This is opinion evidence by a general physician about circumstances which actually concern communication between a lawyer and a client. And the issue between the lawyer and the client
So do you
is
say
about...
so I was looking at paragraph 30. Do you say that's outside her expertise? Does a forensic physician have any role saying what an immigration removal centre needs to do or not do?
No. The role of the expert is to assist the court, of course, on matters within the expert's expertise.
I suppose she can talk sensibly about her experience in dealing with vulnerable and damaged women in the context of her medical career. And she can say, in my experience, so the last sentence of paragraph 30 is, I mean, it makes sense. You can say, in my experience, you need to have in-person contact because that makes it easier to build up trust and rapport and so on. But she's certainly not entitled to comment on what an IRC needs to have.
No. If she'd been giving oral evidence and my learned friend had said, is Derwent's side fit for purpose, in your opinion, the judge would have stopped her and said, you can't possibly ask that question. So, that's, I think your ladyship perhaps articulates, without necessarily adopting, of course, I accept, but articulates the point that I'm perhaps seeking to make.
Sorry.
How
annoying.
But that's, no, I accept it with gratitude, as counsel always does. But that's why I submit that limited, very limited, though undoubtedly the learned judge's reasoning is in this context, one can't simply characterise this as being a case where an expert gives uncontested expert evidence and the judge is under an obligation, if the judge is going to reject it, to set out detailed reasons why. This is very much more a matter of impression. It arises in a context which is to a large extent, though not, I of course accept exclusively, within the judge's expertise, namely legal advice and mechanism for delivering legal advice, and where actually the evidence that was put before the court is in part inadmissible, and to the extent that it's relevant, is by no means conclusive, even if taken at its highest.
So the extent she talks about the need for physical proximity as a way of building trust and so on, and persuading people to say things that they might not otherwise, her CV is pretty well in point and very extensive. I mean, she has huge, if her CV is taken at face value, and I've no reason not to, she has huge experience of working in this field, of working with victims of rape and torture. So that whether or and she purported to be an expert, she purported to give opinion evidence, she gave an expert's declaration. As far as I'm aware, the point was not taken below that she wasn't an expert. Her views can't simply be dismissed on the basis that they're not like a report on causation in a medical legal report.
No, of course not. No, it's not. My submission doesn't go as high as that. Of course, I accept that. But the court had to make an overall assessment, as will this court if the court accepts my learned friend's invitation to set the judge's reasoning aside and think about it afresh. And of course, subject to all the legal points I make, if the court thinks this is nevertheless a potentially dispositive issue, this court will have to make its own assessment. But my point is simply that notwithstanding all of those factors that one might put, as it were, in favour of that evidence, nevertheless, the ultimate issue is one that the judge had to deal with, which is to a large extent within the judge's field of expertise. But it's not necessarily about whether. What we're concerned with here is not necessarily about whether a person who is being interviewed remotely by a lawyer will give a full account of everything that's happened to her. What we're concerned with is access to justice, which depends upon the ability of the lawyer to pick up that there might be something here that needs to be looked at further. It's not quite the same thing as saying, well, over remote means you wouldn't open up completely.
I mean, I understand you have a number of legal points which you say would have to be decided against you before we got to this. So don't get me wrong. But assuming for the purpose of this argument that we were against you on the points such that this issue was relevant or was determinative. The difficulty with this is putting us. I understand entirely my lady's point that the question of fitness for purpose expressed as such is not for this witness in that narrow sense, because she's not an expert on design of detention centres as such. Let's put it that way. And maybe that was one of the issues I would have raised about the rather leading way in which some of the questions were put. But picking up my Lord's point, I mean, she has a CV which undoubtedly renders her, I would have thought, an expert in dealing with vulnerable people who may have been the subject of trafficking or torture or inhuman and degrading treatment, domestic abuse and the like, and I would have thought is entitled to express an expert opinion on how best those people are served in terms of being given assistance, whether legal or otherwise. And for example, at paragraph 9, she talks under the heading disclosure of, she said, in-person legal visits have important and critical advantages over remote contacts, whether by telephone or video link, and then goes on to explain that over several paragraphs that we were shown. And I struggle to understand why that you might say that that's not within the scope of her expertise to express those opinions on the basis of that.
No, I don't say that everything in the report is outside the scope of her expertise. What she can't do is and I think in fairness to her, she does at one point say, strictly speaking, it's outside my expertise.
But I'm going to say it anyway.
But yes, but she can't opine about the can't opine about the ultimate issue. She can't opine.
But if you put the first sentence, for example, of paragraph 9 at page 275, up against the second paragraph of the judge's judgment at paragraph 106, they're pretty starkly and diametrically opposed, aren't they, on any view?
Well, what the judge goes on to say, one has to read the whole of paragraph 106, set it all in context. Obviously, there's a tension between those two sentences, I agree. The judge says that the quality and convenience of modern video conference facilities is very good and comparable to an in-person meeting, which I submit as a finding she was perfectly entitled to make.
For who? For what type of person?
Well, generally, the quality and convenience, the quality...
Okay, so you're now limiting it simply to what technical, pixels on the screen or what?
Well, she...
I mean, if by quality and convenience you mean ability to achieve a result, or for whatever the purpose of the communication is, you've got to take into account, haven't you, who's at either end of the communication.
Well, it's not just that bit, but she then goes on to say, I mean, she is talking there about the fact that the extent of the technical extent, I accept the technical extent of the communication is comparable to an in-person meeting. Then she says that high-speed Wi-Fi newly installed at Derwent-side. Alternatively, the telephone is an adequate means of communication for most people. I accept it may be less effective for those with disabilities and mental health issues. The importance for present purposes of that is the word adequate. She's looking here at adequacy. Is this adequate? And by implication, if the telephone is adequate for most people, then the video conferencing facilities are even more adequate. And in our submission, that's an analysis that she's perfectly entitled to adopt, and one can't infer from anything in this that she has simply overlooked what's been said in the expert reports. It's just that she's had to, in this context where she's looking at adequacy for a particular purpose, which is very much within her expertise rather than within the expertise of the expert. The expert's obviously an expert, I accept, on how people in this sort of situation tend to behave. But the judge is the expert on delivery of legal advice.
Can we just cut to the chase on this? One, there is information and material in the judgment to indicate that the judge had in mind the evidence that was provided on behalf of the claimant, SPM. Two, she did not comply with Lord Justice or Lord Carnwath's injunction about anxious scrutiny, which is set out in paragraph 838 and which we've looked at today. And that's where we are. You're not submitting, are you, that what she's done is compliant with the Carnwath injunction, which is conveniently set out, I was reminded yesterday, at paragraph 38 of the appellant skeleton. No, it isn't. 31. Perhaps. 28. The intensity of the review is high. It is important in particular to establish whether the decision maker has indeed observed Lord Justice Carnwath's injunction that every factor which tells in favour of the putative victim's case has been properly taken into account. So if we're in that territory, you can't submit that she's complied with that, can you?
No, if we're in the territory of MN, of having, and the cases referred to in MN, of a putative victim of trafficking saying here are 6 reasons why I'm a victim of trafficking, and the judge just doesn't address 3 of them, then of course in those circumstances one sees that there hasn't been sufficient scrutiny. I expect Your Lordship is effectively putting to me, well, look at all the evidence that's dealt with here, and the judge doesn't say in terms why she takes.
I'm not so fussed by saying in terms. I'm not asking for a checklist, but something to indicate A, consideration of the points that were made on SPM's behalf, and B, reasons for rejecting them. Not there.
Well, consideration, because she sets it out in the judgment. So that one presumes that means that at some point, somewhere, the judge was sitting there in front of the laptop looking at the evidence, typing out the bits that seem to be the summary. So that's certainly in the judge's mind.
That's back to Lord Justice Lewison. But if we get into the area of MN, I'm sorry, I'm just repeating myself.
No,
I think you accept, don't you, really, that she hasn't complied with the Commonwealth injunction?
she certainly hasn't gone through and you can't see, well, you can't,
Exactly.
she hasn't demonstrated on the face of the judgment that she has dealt with all of the points that she,
And judges
that
have
she
to
sets
rely on
out.
what they put in their judgment.
I'm sorry, what was that?
And judges have to rely on what's put in their judgment.
Yes, but I do still stick with the submission that in the circumstances, it is sufficient, albeit obviously preferably it would have made my life easier if she'd said it all out at length. What one can nevertheless take from this that the judge had well in mind what the issues were, and this was a case that was argued over 2 days plus written submissions afterwards. She had well in mind what all the issues were. She had well in mind what the evidence was. Claimants had the great advantage of being represented by learned friends who had made their case very clearly and fully. And the learned judge squarely came to the conclusion that in this context, the test being the denial of effective access to justice in real world conditions, if that's right, that test wasn't met. In my submission, that is a conclusion which the court should be reluctant to displace, and shouldn't do so simply on the basis that the judge didn't go through a checklist or set out, to use a less tendentious way of putting it, the judge didn't go through systematically explaining each and every aspect of the reasoning that led up to that conclusion. But my lord, that's not in my submission sufficient reason to set the judgment aside. But if I'm wrong about that, then the question still arises what this court should do with the evidence, and I do still stand by my submission in relation to that very, very much so, that the evidence doesn't, my submission, allow of a finding that the arrangements at Derwent's side were such as to present a real risk of breach of anyone's entitlement to access to justice. Well, I may just take a moment to speak to my own friend.
Yes, how are you doing?
I'm not far off, my lord. I see we're almost at the short adjournment.
Yeah.
What I was proposing, I think what might be sensible is if your lordships and your leadership are agreeable. I've got, I think, one more short point to make in relation to this aspect of things, and then I wanted just to come back and wrap up on my point about the non sequitur doesn't make detention unlawful, and then briefly address Lord Justice Snowden's question about the status of the claimant, and then I'll be through, and hopefully I'll give my friend enough time to respond to everything I've said.
Well, that sounds like half an hour-ish.
Yes.
Depending on the headwind or otherwise that you...
Depending on the strength of the headwind.
Yeah,
yes.
depending on the headwind. Well, and you'll probably submit that if I give you another 5 minutes, you'll be all the shorter and more concise and compelling at 2 o'clock.
I wasn't necessarily averse to saying that, my lord, yes.
Okay. Well,
Are you going to deal with the 6-month point?
Oh yes, I was. Yeah, yes.
Can we just have that quickly?
Shall I do that now? Just tell you.
yeah, do 6 months.
Tell you what I say now about the 6-month point. That was a statement of fact. She wasn't saying, and the learned judge should be credited with having the sense not to be saying that it didn't matter as long as it only went on for 6 months. There's no reason to think that the learned judge thought that it was okay as long as it didn't go on for too long. So, on that basis, I will endeavour to keep my submissions as brief as I can after the short
That's
adjournment.
fine. You just take the time you need. 2 o'clock? 2 o'clock.